Good morning, everyone. Welcome to today's hearing. Today we're going to continue hearing evidence from Mr. Carl Stokes. Would you ask Mr. Stokes to come in, please?
Thank you.
Good morning, Mr. Stokes.
Good morning, sir.
All ready to keep going, I hope.
Sir.
When you're ready, Mr. Millett.
Mr. Chairman, good morning. Good morning, members of the panel. Good morning, Mr. Stokes. Mr. Stokes, last night when we finished your evidence for the day, we were discussing evacuation plans and communications with residents. Can I next take you to, or take you back perhaps, to your 30th of September 2009 fire risk assessment that you did for Grenfell Tower while at Salvus? That's at CST 403128. And in that document, please go to page 16, and let's look at your recommendation at line 5.2, middle of that page. And you say there, it is recommended that the TMO establish contact with tenants to confirm that the letter indicating response in the event of a fire has been fully understood and tenants are aware of the emergency plan. Did you yourself ever check if the TMO had established contact with residents to confirm that the letter had been sent, let alone understood?
Specifically, no.
Why was that?
Because when I went or undertook the next FRA, I would have checked up on this, and it was part of my briefing. I think the letter, I checked to see whether the tenants had information via the handbooks, information link, etc. later on.
So did you check or didn't you check?
This I wouldn't have checked, no.
Right. Even at the next FRA?
I would have checked that the action would have been undertaken. Yes, it would have been checked that way.
Sorry. Did you check at any time to see whether the TMO had established contact with tenants to confirm that the letter indicating the response in the event of a fire had been fully understood by them and that they understood the emergency plan as you had recommended?
Confirmed in as much as that a letter had been given to the tenants, but I would never have known of every tenant because of the turnover of the tower and the residents, whether everyone understood it. That was a TMO responsibility.
Yes, indeed. Now, my question was whether you ever checked that the TMO had established contact.
I would have asked the question, has the letter or has this item been ticked off?
And you say you would have. When did you do that?
I would have done it before the next FRA.
Right. Now, you say at paragraph 150 of your first witness statement, CST 403063, page 51, please, para 150, that, bottom of page, you say, sorry, top of the page, you say, under Little Roman 1, the DCLG high-rise guidance GRA 3.2 states that an evacuation plan where there is a stay-put policy should be part of the fire service's contingency planning. And then Roman 2, it was the KCTMO who were aware of the particular needs of individual residents. 3, as noted in paragraph 50 above, this wording was included in the sample FRA that the KCTMO and LFB had reviewed and which neither organisation had at any point queried. And then you say, I do not know for certain whether such a contingency plan was prepared, but I was never made aware of one. That would, however, in my view, be an issue for operational firefighting and not FRAs. So just to clarify, going back to the meeting of the 24th of September 2010 that you had with Janice Ray, is it right that you had received no assurances from Janice Ray that the fire service would arrange a general evacuation of any of the buildings in the TMO stock?
So I'm unsure what you're actually asking me. I would not have any input or actually no knowledge of LFB's operational procedures, no.
No, my question is, am I right in thinking that Janice Ray gave you no assurance at the 24th September 2010 meeting that the fire service would arrange a general evacuation of any of the buildings in the TMO stock?
Correct. Yeah, she wouldn't. Would she know what the operational fire service procedures or policies were?
And it's also right that you were not told about any plans that the TMO had put in place, so that TMO staff could arrange a general evacuation of any building in the TMO stock.
I had no significant plans for any building, no, but there would be a general understanding that they could evacuate a building.
General understanding. Did Janice Ray ever tell you or give you reason to think that the TMO had any plans or arrangements in place for any building in the stock by which the TMO staff, as opposed to the LFB, would arrange for a general or partial evacuation of that building in the event of a fire?
No.
No. Is it right that when you drafted your FRA for Grenfell on the 29th of December 2010 and each subsequent FRA for Grenfell thereafter, you received no assurances from the TMO that they had made any evacuation arrangements that its employees would be able to activate in the event of a fire at Grenfell?
Correct.
Yes. Do you agree that, given that you didn't know and were not told of any specific information about whether a general evacuation could be carried out for Grenfell Tower, then you shouldn't have included that information in the FRA at all?
There would always be, you could always evacuate a building. If it's an emergency situation, the emergency services would take over. The situation where it would be the TMO would evacuate a building would be a non-emergency situation where they had other reasons to undertake that evacuation. So it would be in slow time, knocking on doors, sending people in. It would be a very general evacuation plan.
If we go back to CST 403181, page 5, please. We were looking at this yesterday. This is the part of this FRA which refers to the evacuation strategy for this building, and we were looking at it shortly before we finished last night. If you look at the last sentence in that paragraph, it says, the landlord relies upon the tenants to respond to any emergency in accord with agreed emergency plans and does not facilitate any fire drills or other emergency evacuation exercises. Given that this was the section of the FRA which was meant to contain specific details about the evacuation strategy for Grenfell Tower specifically, it's right, isn't it, that there were no agreed emergency plans?
The emergency plan was the stay put policy. So the resident would, in event of a fire or affecting their dwelling, they would leave. Otherwise, it's stay put.
And looking further up the box to the middle of the first paragraph, where it says, the fire service or TMO, or RBKC, or the TMO employees will arrange for a general evacuation of the building at any time if this is appropriate. It was wrong and misleading, I would suggest, for you to suggest that the TMO employees would arrange for a general evacuation of the building in circumstances where Janice Ray had never given you any reason to believe that there were any arrangements by which the TMO staff would do so.
Partially correct, but it's common sense that there would be, if it was an emergency, if it was a fire emergency, the fire brigade would take over. Any other sort of emergency, the police would take over. If it was non-emergency and an evacuation was needed for some other reason, the TMO would have facilities to do that. That would be, you could knock on doors, you could ring the buzzer on the ground floor, and they would have contact details of telephone numbers of people. So in an emergency, it was reasonable in my view, and also checked with them, because this paragraph would have come out of the meeting I had with Janice Ray to start with. to say that the TMO could arrange an evacuation of the building at any time if they needed to. An emergency situation would be the fire service if it was a fire, and that would be covered by 3.2.
But there's no distinction in this paragraph where you're setting out the evacuation strategy for this building that says that the TMO employees would only arrange for a general evacuation in a non-emergency situation. That distinction doesn't appear in this text, does it?
No.
No. On the contrary, do you accept that the impression given to the reader of this document is that in the event of a fire, either the fire service or RBKC or TMO employees would arrange for a general evacuation?
I disagree, because if there was a fire under the Fire Services Act, the fire service would automatically take control, so they would be in control of the situation, and RBKC would just be helpers to the fire service. And they would have contingency plans anyway. It's a requirement that you have contingency plans, the same as the fire service would have a requirement.
This makes no sense, with great respect, Mr. Stokes, because if you read on, it says TMO employees will arrange for a general evacuation of the building at any time if this is appropriate, or the resident can leave at any time if they so wish. Well, in an emergency, a non-emergency situation, why is it relevant that the resident can leave at any time if they so wish? This is talking about a fire, isn't it?
No, this is talking about the evacuation strategy for the building. It doesn't say if there is a fire. It is to do with fire, but there could be other emergencies within the building.
Well, with great respect, you are a fire risk assessor assessing the risk of fire for the purposes of the RRO.
Yes.
And the first sentence of this part of this part of the FRA is all about what happens in the event of a fire in the building. That's what it says.
And it's stay put policy.
Indeed. So my question to you is, what were the arrangements under which the TMO would arrange for a general evacuation of the building in the event of a fire?
They would follow what the fire service asked them to do, because the fire service would take control.
Do you accept that idea is not only not reflected in what you've drafted here, but is in fact completely contrary to what you've drafted here? Because you say here that the fire service or RBKC or the TMO employees will arrange for a general evacuation.
If that's the way you read it, yes.
It's right to say, isn't it, that you used the same information about the evacuation strategy from your meeting on the 24th of September 2010 in all of your fire risk assessments for the TMO, regardless of the building that you were assessing. Do you accept that?
No.
Well, let's look at some of the other properties that were deemed by the TMO to be high risk and which were also high-rise buildings. Let's start with Adair Tower. Fire risk assessment, 28th of October 2010, please. CST 404307, page 5. And what I'd like to do is leave the existing one up on the page, on the screen, and have this one next to it, please. So let's keep that on the screen. That's the Adair Tower fire strategy for October 2010. Let's have at the same time the document we were just looking at, please. That's CST 403181, page 5. And let's compare and contrast. If you look at the right-hand side of your screen, that's what we've just been studying in some detail this morning, Mr. Stokes, already. On the left-hand side, we have the Adair Tower fire risk assessment of the 28th of October 2010, page 5, same section. And it says, if you cast your eye to the left, it says, evacuation strategy for this building, and then you can compare the text. And the text is identical, isn't it? At least down to the last 3 lines. The only thing that's different is the last 3 lines, isn't it?
That's correct, because the buildings are similar. They do not have a fire alarm system installed within them in the common parts. Therefore, they are similar buildings. They would not This evacuation strategy would not be for a building that had a fire alarm installed in the common parts.
So identical is it that you cut and pasted from one to the other?
Correct, because that's the letter we had at the beginning, which went through with the TMO. This would be used on all the buildings with a similar layout, systems, etc., within that building.
Including the typographical errors. As you can see, just picking one up, just below halfway down on the left-hand side, the text articles has got a rogue apostrophe in it, and so is the one on the right. So you've actually cut and pasted even the typographical errors.
Because this would be used, as in per the letter, this would be used for all their buildings unless there was a fire alarm system installed.
So was your approach a one-size-fits-all?
No, it's a site-specific, but the evacuation strategy for each building would be the same. If you notice on this Adair, though, there is no employees in Adair, so it is different. It's only for the residential parts that's the same.
Well, indeed, 5 lines down, in the box on the left-hand side, you say the fire service or TMO employees will arrange for a general evacuation of the building at any time if this is appropriate. So we've still got the reference there to TMO employees arranging for a general evacuation, haven't we?
Yes.
Yes. Although I notice, in fact, although I said to you that it was identical, for some reason, the reference to the Royal Borough of Kensington and Chelsea arranging for a general evacuation is not there in that sentence on the left-hand side. Why is that?
I can't answer that. Maybe it's updated slightly with information given.
Let's look at the Gilray House Fire Risk Assessment, TMO 0085490. I'm going to assume that the text I've been showing you for these 2 risk assessments is now reasonably familiar to you. Let's go to this one. This is now Gilray House, 19th of November 2012, as you can see from page 1. If we go to page 5, same section of the FRA, Evacuation Strategy for this building. And there again, we have the same text as we've seen down to the last 3 lines, as we saw in the Adair Tower, November 2010.
So this was 12. The first one you showed me was 10, so it's obviously changed with information been given to me over the 2-year period.
Except that it hasn't changed, has it, in respect of all of it down to the last 3 lines? It's the same.
This is...
You've corrected the apostrophe, I'll grant you that, but the rest of it's identical.
Yes, because the policy wouldn't change within the building. No matter when it was taken, it was still a residential building, and that would still the stay put. If you notice on this one, it doesn't say defend in place anymore. It just says stay put.
And I do you a slight disservice. There is also a reference here to the TMA providing information to all residents in tenants' handbooks. By this stage, had you seen the tenants' handbook?
Yes.
And what was the information provided in it?
I can't remember it per se, but there was information in the tenants' handbook. And I think over time it was a case of it was given to them, and I asked questions on whether they signed for the handbook, etc., etc.
Right.
As my risk assessments progressed, we got more and more information.
But the essential advice is identical.
Yes, stay put.
And if we look at Hazelwood Tower, 20th of February 2014, TMO 100,43804, at page 5. You could see page 1 to pick up the date of the Hazelwood Tower FRA, first of all. Page 1, 20th of February 2014. Page 5, top of page, evacuation strategy for this building, and the first, second, and third paragraphs are identical to the fire risk assessment we've just seen in relation to Gilray House 2 years earlier. Yes?
Similar, yes, I think, without reading it, but yes, similar.
Yes. And we can move forward 2 years on to 21st of January 2016, your FRA for Markland House, TMO 100,47159. 100,47159, Page 1, first of all, there's Markland House, there's the date, 21st January 2016. Page 5, please, top of the page. Same block of text again, same text again. And note, like all of these, it says fire service or TMO employees will arrange for a general evacuation of the whole building at any time if this is appropriate to do so. And then finally, in this run of comparatives, Trellick Tower, 26th of April 2017, at TMO 00842-255. Let's have page 1. TMO 00842-255, page 1. There it is, Trellick Tower, 26th of April 2017, and page 6 in that second box, evacuation strategy for this building, and again the all familiar text, including the words that the TMO employees will arrange for a general evacuation of the building. And it's essentially exactly the same for all the FRAs we've seen back to 2010, isn't it?
It's similar, but there's always site-specific. So like on this one, there is information in the last paragraph about fire on the balcony and which flat number. So they're all site-specific, but the policy of evacuation is still going to stay the same no matter what date it is or what building, if it is a residential tower block.
So can we take it that the paragraphs we've seen in all of these FRAs across the years in respect to the evacuation strategy was for the most part taken from your meeting with Janice Ray on the 24th of September 2010?
Correct, and the way the buildings were constructed as stay put.
And I'm right in just reinforcing the point to you. You never received any specific assurances from Janice Ray or anybody else at the TMO that the evacuation procedures set out in these paragraphs that we've seen were specifically in place for those buildings and were going to be followed on a building-by-building basis.
And I was never given any adverse comments either. The TMO have these documents, they revised them. The fire service looked at these documents, the fire service revised them and issued broadly compliant letters for these buildings, and they were happy with that statement as well, that they would evacuate the building and had procedures in place.
Now, after your meeting with Janice Ray on the 24th of September 2010, did you ever check whether the evacuation procedures that you wrote about in any of these FRAs were in fact in place for each building? Or did you just assume that what she told you at that meeting applied to all the buildings, at least all the high-rise residential buildings in the TMO stock?
Well, stay put would have been a given because it would be up to the individual, as it says there. If it affects your flat, you would leave the building. I would have no access at all to the fire service and whether I could ask them, but as they did not come back with any adverse comments, they were shown these as draft documents. These were the base documents for all the FRAs that were given to the LFB to check and to make comment on. There was no adverse comments. And the TMO made no adverse comments that they could not undertake the evacuations. So I was under the impression everything was okay.
Were you under the impression that there were arrangements in place under which TMO staff would effect whole or partial evacuations of any of these buildings?
Yes, because common sense would say that if it was a non-emergency situation, you could evacuate the building.
So you still maintain your qualification only in the event of a non-emergency, even though that qualification doesn't appear in any of your FRAs?
But because it would be superseded. If it was an emergency, the fire service would take over, the same as the police would take over if it was an incident where they would take jurisdiction and control.
Now, looking at what's on the screen in front of you, this FRA for Trellick was the 21st of April 2017, and as you note in the last paragraph in that box, 2 days previously there had been a fire in flat 195, as you can see. Did you use that as an opportunity to check whether at the time of that fire the evacuation strategy that you had set out in your FRA above it was still appropriate or had been implemented?
Yes, it was stay put, and the flat was evacuated. The rest of the building, as far as I'm aware, was not. I actually visited the flat and looked round it.
So you did?
Yes.
So can we take it then that the fire, you took that fire as an opportunity to check how the stay put policy was operating at Trellick?
Yes.
You did.
There was other fires in other buildings as well that I went to over the intervening time, and no one, fire service who went to those fires or anything else, raised any comments at all after any of the fires. I would always ask for fire reports from the fire service via Janice Ray, who she would always get them and pay for them from the fire service. No adverse comments were ever made about any problems with evacuation policies, procedures from the LFB or the TMO.
After 2010, did you ever have a discussion with Janice Ray about whether the assumption that you were working from, as reflected in all of these paragraphs across all of these FRAs, was a tenable one?
We would have had, because it would have been checked after a fire in a building. Did it work? Was it okay? Was there any problems? We used to have a part of the meeting, if we did have, when we had meetings, was any notices issued by the fire service, any visits by the fire service, any comments. She would have, I'm going to say monthly meetings. They could be 2 monthly meetings with the fire service. That was an agenda item, so there was always a route coming back that way. And if there had been any comments, it would have been fed back to me, or I'd like to think it would have been fed back to me through those meetings. And if anyone had any comments when I was walking around a building, they could have always have asked me.
Did Janice Ray ever ask you the question, is it okay if we don't have any alternative evacuation arrangements in any of our high-rise residential blocks?
I would never have thought that would have been a question, because it's got to be a given. You've got to have an evacuation procedure and policy.
Yes, and what was it for any of these buildings?
Stay put.
No, sorry, I've misunderstood, or rather, you've misunderstood. Did she ever ask you the question, is it acceptable that we don't have any alternative evacuation arrangements? In other words, an arrangement to evacuate a building in case stay put is no longer tenable?
I wouldn't have, that doesn't spring to mind, no.
No. Did she ever ask you why, did she ever ask you whether you had checked each building to see whether, in the case of a fire in such a building, an alternative arrangement for full or partial evacuation of the building was necessary?
That does not ring a bell, no.
Am I right in thinking, from the discussion that we've been having over the last 10 minutes or so, that the idea of a full or partial evacuation of a high-rise residential block by way of Plan B was something that you never thought about and never provided for in any of your FRAs?
If it was a fire, the fire service would have taken over, and everyone works together. It's a big jigsaw, and you have to rely on other people to undertake arrangements or procedures as per their policies, which I've got no privy to or information to. And if there is a fire, all I'm looking at is, in the evacuation of this building, is a stay put policy. Please, on this document, there is the criteria that I undertake the document to, which is the building regulations and 9991 criteria, that the fire will not be within a common part, it will be within one flat only, and that is the criteria you work to for the evacuation policy. If it's a full building evacuation policy, that's outside the remit of the fire safety of my risk assessment, because I'm only looking at a building that's got a fire in one flat. There is the criteria, please, on the document for which this FRA applies to.
Was it your understanding, and I ask this question in an attempt to understand your evidence, Mr. Stokes, but was it your understanding that the responsible person under the RRO was not required to make any plans for a full or partial evacuation of a high-rise residential block in cases where the stay-put policy became no longer tenable.
It would be the fire service responsibility under, because it's the Fire Services Act, they have taken control in a fire situation.
So is the answer to my question yes, that your understanding was that the responsible person under the RRO was not required to make any such plans?
If that's the way you're putting it, yes.
But I don't want to put words in your mouth because this is not a straightforward topic. Let me ask it in a different way so that we're clear. What was your understanding at the time about the extent of the responsible person's obligations to put in place plans for a full or partial evacuation of a high-rise residential block in circumstances where a stay-put strategy or policy became untenable?
The responsible person would revert back to the fire service, because if there was a fire in the building, they would take control of the building, but there would be I would like to think there would be a procedure in place for a non-fire emergency where they could evacuate the building, which would be done in slow time and under a controlled way. In the fire situation, it would revert to the fire service to undertake an evacuation.
And what, in relation to the non-emergency situations, did you understand to be the TMO's arrangements for full or partial evacuation of the building by their staff?
It would be done knocking on doors, intercoms. It could be a major water leak in a building that's flooding out flats or something like that. That would be the sort of situation I would envisage that the TMO would have to evacuate with no help from an outside emergency body.
Did you ever see any policy or strategy or plans to that effect?
No.
Did you ever ask for any?
Isn't it not covered in the fire strategy document? Isn't there a section in there about evacuation?
Well, Mr. Stokes, you must answer the questions about that because you were there and involved at the time.
I'm going to say there's a section.
What is the answer?
There's a section in the strategy document.
Was it that to which you were referring in your fire risk assessments, when you were referring to the TMO employees arranging for a general evacuation of the building at any time?
And back to the letter of when I first started, which was all agreed, this was the comments and statements that I would put down.
Did you ever ask Janice Ray for details of the TMO's system of emergency planning for Grenfell Tower or their wider estate portfolio?
No.
Why is that?
Don't know. I can't answer the question. But it's not. Is it in part of the risk assessment?
Right. Can we go to CTA 703, page 71, please? And what I'm going to show you is Appendix F of PAS 79 of 2012. Left-hand column, second bullet point. This is about the means of escape. And it says in the first introductory set of words, accordingly, the fire risk assessor should be able to, and then second bullet point, understand the principles of emergency planning and evacuation. Do you accept, looking at that it was your role to be able to understand the principles of emergency planning and evacuation in place or put in place by the TMO?
Correct. And then, as I explained, the principles are, I understand the principles, emergency planning. If it's a fire, the fire service would take control.
So is it your evidence that so far as you are concerned, the texts that we've been reading across the FRAs in the 7 years from 2010 to 2017 encompassed that obligation?
Yes.
I see. Were you aware that the TMO did not in fact have a written emergency plan specific to Grenfell Tower in place?
Would that not, with TMO or RBKC?
Well, the TMO, well, put it this way. Let me try it more neutrally. The responsible person.
I would not know that answer to that question.
It was a requirement, wasn't it, under Article 11 of the Fire Safety Order?
So you'd have to refresh my memory of Article 11.
Well, rather than getting into the detail, are you able to answer the question whether you knew or didn't know that having an emergency plan in place was a legal requirement for the responsible person?
Well, the emergency plan is stay put.
And a written emergency plan, a document.
A document, so the handbook, the handbook would be the policy, it's written. Stay put is the policy and procedure.
Did you ever see, let me try it a different way, did you ever see a written emergency plan specific to Grenfell Tower that satisfied the responsible person's legal obligations?
No.
Did you ever ask for one?
A full document by the TMO for that building, no.
Can you explain why you didn't ask for one?
Because it's covered in my statement there, and I asked the question. No one come back to me with any adverse comments that they didn't have one. And the fire brigade, in my view here, the understanding is the principles of emergency planning, yes, and the evacuation policy is stay put.
Now, can we go please to the 2014 FRA at CST 403157. I want to ask you some questions about what the LFB thought about this. Can we go to page 7? That's the first page there, 17th of October 2014. Page 7, under the heading, any other relevant information about this premises, on this premises. And then if we turn the page, please, you see that it says an audit under the RRO was undertaken in this building by Fire Safety Inspecting Officer Matthew Ramsey of London Fire Brigade, with a notification of fire safety deficiencies being issued, and you identify the deficiency notice of the 24th of March 2014 there, and you set out the contents of it and the three main requirements in the notice. And then if you go to the second part of the page, can we scroll down, please, to the lower part of page 8. It says the fire officers did not commented, either at the time of the audit or in any correspondence after the audit, about the building's layout, the means of escape routes, compartmentation, etc., nor were there any comments about the positioning or siting of the fixed systems within the building, only about the maintenance of the systems. No adverse comments were received either about the management policies, procedures, and arrangements in place within this building at the time of the audit. Therefore, has been assumed that the fire authority were completely satisfied with these arrangements at the time of the audit, and there have been no changes to the residential part of this premises or the TMA's management policies or procedures since the above fire safety audit was undertaken. Now, this statement also appeared in the two subsequent FRAs for Grenfell Tower, didn't it, in 2016?
Because an audit had been undertaken, yes.
Yes. Why did you include that statement in the two subsequent FRAs?
Because an audit had been undertaken. Without seeing the FRAs, the audit would probably give the same address, the FRA would give the same date, etc. And if the fire service had made no adverse comments, that is a positive comment, therefore that they were aware of the building, its layouts, and the management's policies and procedures. They made no comments adverse against them, therefore they must have been correct.
Did you explicitly agree or expressly agree with Janice Ray to operate on that assumption, namely that if the LFB didn't comment adversely, then all was fine?
But the notice would have, if there'd have been any adverse comments, if the answer to your question is yes, I would have got the deficiency notice from Janice Ray, and she would have seen this comment and they'd made no adverse comments about it.
Let's just see what Ms. Ray says about it. Can we please go to her first statement? This is TMO 50890, page 32, paragraph 143. Now, she says in the second line, there was an assumption made by Carl and myself that arrangements at our premises which were not negatively commented on by the LFB following audit were deemed by them to be satisfactory. Now, she speaks of an assumption made by you and her. Was that assumption something you agreed together?
It was a positive statement. I mean, I would have made that comment to her. Is there any adverse comments? No. So we put it in as a positive comment.
Did this assumption that she's referring to here rest on any specific assurances that the TMO or you had obtained or received from the LFB?
There was no negative comments, therefore they must be positive.
Right. Were you ever told by Janice Ray or anybody else at the TMO that the LFB were not content with that approach?
I was told no information at all, no.
I see. I want to turn next to ask you one or two questions about risk ratings, which you gave to Grenfell Tower specifically. Can we go back, please, to the 2014 FRA, CST 403157, and let's go in it to page 9.
I think you're going to have to wait a moment, Mr. Millett.
I am. I just realised. Mr. Chairman, I think we may need to take a break. I'm told that I think our operator is perhaps temporarily indisposed.
Well, we can. I've noticed he's been in and out of the room, but not for any extended period. Would you rather we weren't sitting here, as it were?
I think I would. I mean, I hope it's not going to be long.
In that case, we'll rise for a moment. Mr. Stokes, I think we're going to have a short break now. So would you like to go with the usher? And remember, as I've said to you before, please don't talk about your evidence to anyone.
Sir.
All right, you can ask the usher to come and get us when you're ready.
Yes, Mr. Chairman.
Before I ask Mr. Stokes to come back into the room, can I just explain for those who are watching, I'm sorry about the interruption to the proceedings. I'm afraid that the document manager, who normally does such an excellent job in getting the material on the screen, has been taken ill, and that inevitably involved an interruption to the proceedings. We've made arrangements for the documents to be put up on the screen by a remote process, which we hope and expect is going to be entirely efficient. But we'll just have to see how we go. Anyway, we are now ready to continue. So I shall ask Mr. Stokes to come back, if he would, please. Welcome back, Mr. Stokes. I'm sorry about the break in proceedings, but as you know, we had a technology problem. Anyhow, we think we've resolved it satisfactorily by an alternative means, so we'll see how we get on.
Sir.
All right, thank you. Yes, Mr. Millett.
Mr. Chairman, thank you. Mr. Stokes, can I next turn to the topic of risk rating? Can we look, please, at the 2014 FRA at CST 403157, page 9. Now, this I'm showing you is under the title Fire Risk Assessment for the areas of Grenfell Tower. And is it right that you used a risk estimator to calculate the category of risk to life from fire in the premises?
Correct.
If we go to page 10, please, you can see that by way of conclusion, at the top of the page, it says, accordingly, it is considered that the risk to life from fire at these premises is tolerable in a range from trivial at the bottom to intolerable at the top. You see that?
Correct. Yes.
Does that mean, according to this table on page 10, lower down, tolerable, as you say, that there are no major additional controls required? However, there might be a need for improvements that involve minor or limited cost. Is that how that's supposed to work?
Yes.
And without going to each and every fire risk assessment that you did for Grenfell Tower, would you agree that in each and every one, this is what you said? You ticked the tolerable box.
For Grenfell Tower, yes.
Yes. Now, I want to look next at your significant findings schedules. They all followed the same structure and format for Grenfell Tower, didn't they?
Yes.
Yes, and I think it's right that, in fact, you used a template across the whole of the TMA stock for your significant findings schedules.
Yes.
Yes. Can we look, please, first at PAS 79, CTA 703, page 59. And if we go to section 19 on that page, you can see it's entitled Formulation of an Action Plan, Commentary on Clause 19. And at Little Roman 1, it says, the outcome and indeed the principal raison d'etre of the fire risk assessment is the action plan. The action plan comprises recommendations that are intended to ensure that the fire risk is reduced to or maintained at a tolerable level. And then in Little Roman 2, you see it says this, in formulating the action plan for premises in which the fire risk has been assessed as unacceptably high, the analytical approach to the fire risk assessment permits backtracking to determine whether, in effect, the problem arises from inadequate fire prevention, i.e. inadequate means for control or elimination of fire hazards, inadequate fire protection, e.g. unsatisfactory means of escape or fire warning systems, shortcomings in fire safety management, or a combination of these. Were you aware of those principles at all times when compiling FRAs for Grenfell Tower?
Yes.
And did you apply those principles when drafting your significant findings schedules for Grenfell Tower in every case?
Yes.
Can we then start by looking at your action plan of December 2010, as part of the FRA at that time, CST 403165, page 1. And if we could have that expanded, please, a bit, you can see that the date of this on the right-hand side is the 29th of December 2010, and then about a quarter of the way down the text, priority timescales, high, 2 to 3 weeks, medium, 1 to 2 months, low, 3 to 6 months.
Yes.
And as you can see below that, you give each action a priority rating, which indicates that when you expect the remedial action to be taken. Is that right?
Yes.
And that means, does it, that the action should be completed and closed off within your timescale? Yes?
On this document, yes, but you'll notice on subsequent ones, the timescales have altered, and also there is a in brackets at the end to say to the start of any work.
You are right, and we're going to come to those. On this document, however, am I right in thinking that the timescales that you've set out here mean that the action should be completed and closed off within that timescale?
That would be the indication, yes.
So that was the position at December 2010.
Yes.
When you inserted those timescales into your record of significant findings and action plan in the December 2010 FRA, how did you determine the priority timescales for low, medium and high?
I think they would have come from the documentation that was available at the time. This is before the purpose-built block of flats guidance came in, where additional information then came in about this.
When you say came from documentation that was available at the time, what?
And it would have been agreed with as a draft document with the draft one that went to the TMO and LFB.
When you refer to documentation at the time, what was the documentation?
At the time would have been the PAS, whichever relevant document, the sleeping guide. I believe Lakers was in, but wouldn't be relevant to this building.
So documentation means guidance, not,
Guidance, sorry,
not
yes.
TMO documentation.
Sorry, correct. Yeah.
Thank you. Now, when we go to the 2012 version of the action plan, let's look at that next. CST 403083. We see now what you were referring to a moment ago in your answer. This is 20th of November 2012, to go with the FRA for Grenfell Tower of that date. Now we see the priority timescales: high 2 to 3 weeks, medium 2 to 3 months, low 6 to 12 months. Why did those priority timescales change from the scales we saw in the December 2010 significant findings and action plan?
I would say guidance provided by HM government and other documentation in industry standard.
What? Can you be a bit more specific? What specifically was the guidance or industry standard that had come out in the years?
Purpose-built guide for flats.
Right. Because, of course, we also had at this point, November 2012, PAS 79 from August that year. But those two guidances, or sets of guidance were new. What was it in those sets of guidance that caused you to extend the priority timescales as we see here?
I can't answer that question. It was back then.
Well, I am asking you to answer that question as best you can.
I would have altered them because of relevant guidance that was available at that time, and they were the standards that had been looked at or accepted as relevant for that time as across the board.
Well, was there anything specific in the new guidance that you have identified which told you that you could or should extend the time for priorities?
Without seeing the documents, I can't answer that question. No.
Or was this you reading the new guidance and using your judgment to identify priority timescales as best you saw them?
Probably that. If I haven't seen, I can't remember the documents per se, but I would have only altered them if there was guidance available to me to alter.
Did somebody in the TMO ask you to change these priority timescales?
I'm going to say no, because those priority timescales would have moved for all documentation or all significant findings for whether I was working for the TMO or elsewhere.
Right. So do I take it from that answer that you shifted your priority timescales across the whole of your professional work?
Yes.
When did you start doing that? When was the first time that you extended your priority timescales?
I can't give you a specific date without looking back at documentation.
Can we then look at the next FRA for Grenfell Tower, 2014, CST 403177, page 1. This is the 17th of October 2014 record, as you can see. And now we have priority timescales: high 2 to 3 weeks, medium 2 to 3 months, low 6 to 12 months, with the words in brackets added at the end to start to action any works, close brackets, after the 6 to 12 months. Why was that qualification added at that time?
For the best of my memory, it was for financial reasons, because if companies were coming back and saying, well, we have to undertake capital work, we need authorisation. So to the start of any works, it's now been actioned. So if it's high, but we've got to spend £100,000 putting a new fire alarm system in a factory, they need capital money to undertake that work. So therefore, they started to undertake the work. They now need the finance in place, and also in that particular example, a company might not be able to start work for 2 weeks, 3 weeks, 4 weeks.
Just to be clear, does the addition of this qualification mean that you no longer expected the works to be completed and closed off within the timescale that you had set for each action, but just to start?
If possible, completed, but otherwise, if it's financially and they couldn't do it, to start the works, at least it would show that work had been undertaken. And the priority scales is high, 2 to 3 weeks. If it was immediate danger to life, it would have been a immediate action, not a priority timescale where there would be the benefit of allowing a timescale.
Yeah, and again, to be clear, just to be absolutely clear, this applied only to the low priority timescales, not to the high or medium.
It applied to all timescales, because even if a fire alarm system in a building, not just this building, but any building, needed to be replaced because it had failed, it couldn't just happen overnight. So therefore, it would have to be a caveat put in there to the start of any works. The caveat was only put in there would have only been put in there because of reasons given or advice given in documentations or going to exhibitions or listening to lectures.
Yes, I just want to be clear about what's intended.
The intention is that it starts.
Well, let me just ask the question. The addition of the words to start to action any works that you see you've put in after the low 6 to 12 months, was that qualification in brackets intended to apply to each of the priority timescales?
Yes.
So even in relation to a high priority item, your advice or recommendation was that the work should be started within 2 to 3 weeks?
Yes.
Right. Did that mean that even with a high priority item, the outstanding action, once started, could continue indefinitely?
We'd have to justify that, but yes, potentially.
Did the TMO ask you to add this qualification?
No.
How would somebody reading this action plan know when they should expect the action to have been completed?
Well, when it actually is sorry, I don't understand the question, but when the action is completed to the satisfaction of the person undertaking the work. So I don't understand the question.
Well, if somebody picked up this document and asked, when is this red item, this high priority item, going to be completed? so that the high risk is eliminated, what would they see?
Depending on what the identified risk is and the action to be taken. I mean, reading this one here, the first one would be recommend that building control response to the proposed works being undertaken in the building is asked for.
Yeah.
Well, the TMO within 2 to 3 weeks can ask for that document. If building control doesn't respond back for 4 weeks, it's outside of the control of the responsible person.
Mr. Stokes, perhaps you can help me on this. I noticed that the last column in the table is date to be completed by. And is that something you would fill in?
That responsible person, sir.
Well, you would complete the date, would you?
No, the responsible person.
The responsible person would.
So the document is given to the responsible person in this format, and then by whom. So if I was to give it to Janice Ray, for argument's sake, she would then say, by whom, repairs management, date to be completed. It's for her to put that date in. But
yeah, I understand. All right.
So the action would be undertaken within 2 to 3 weeks by her as that person. She is now waiting on other people. It's a live document, sir.
Yeah, no, I understand. Thank you very much.
Yes. Well, thank you, Mr. Chairman. That takes me to the next question beyond that, which was that would it be right that it would be the TMO, Janice Ray in this case, who would be the judge of the completion date?
Correct.
And would she have any advice, or did she ever get any advice or seek any advice from you as to the appropriateness of the completion date she intended to insert?
No.
So how would the TMO know whether a particular completion date was safe from a fire safety perspective?
I suppose the honest answer is as long as they've completed out the action.
So is it right that by leaving it to the TMO to decide for themselves when the action should be completed, even in high-risk cases, you were not able to assess the fire safety risk arising from the time to be taken?
No. Is that I give the document in. Once I've given the document, it's to the responsible person to undertake the remaining actions of the article.
Did you ever advise Janice Ray that she should come back to you if a high priority item was going to take longer than a week, 6 weeks, a month, anything like that?
No.
You just left it to her, did you?
As I would anyone else. If you were undertaking a risk assessment, not for the TMO, anyone, you could be asked to undertake a risk assessment. You're going to hand the document over to your client. You might never go back to that building again, might never see that document again. This is only your opinion. Your priority timescale is 2 to 3 weeks. For high, the responsibility has now been handed back to the responsible person.
It sounds as if what one can conclude from that, would you agree, is that by changing swapping the finish line for the starting gun, if I can put it in that way, and then not having any control, remaining advisory role over how long the race should be, you were essentially handing back to the TMO a very significant element in fire safety risk assessment.
Correct, and the same with everyone else. You're handing the document back over. You have no onward control of that document.
Did you ever tell Janice Ray in terms that she needed to be absolutely clear that in according a completion date to any risk item, particularly high-risk items, she needed to consider specifically the fire safety implications of the period of time to completion?
Well, that's what is in this document. So I would never had that specific conversation because it's in the document. She would have actioned the documents as and when she got them. That is my assumption.
If the finish line, the finish date for actioning the works had been swapped for the starting gun, I apologise for the metaphor, what real difference was there between high, medium and low?
In the documentation, a high would be, I believe, in the documents we talked about, high would be where it would be a breach of a standard. Medium would be benchmark, and low would be best practice.
I'm sorry to interrupt again, but I'd just like to help on this, Mr. Stokes. You told us a little earlier that the priority timescales had been changed in the light of some guidance.
Would have been, yes, sir.
We can see that the words "to start to action any works" which have been brought into this were not present originally. They've come in. Do they reflect anything in guidance as far as you can remember?
No, but they would have come from industry standard or courses I've been on, or going to CPD days, like, so for instance, the one on the law. You know, it would have been a case of this would have come about because of that information provided. The time, the fire safety order, when it came in, was new. All this is evolved over time as court cases have come out. So therefore, information has been added to risk assessments, hence the PAS is being updated.
Well, I understand that, but I just find it, I speak for myself, of course, but I find it very surprising that the timescales should be related to the time of starting work rather than the time of completing work. Because obviously, if someone in your position is able to identify work that needs to be done, the client perhaps should be told how urgent it is. When does it need to be done, not when does it need to be started? But
I would have, the risk assessor would have no control over how long the work would take to be the length of work to be undertaken. So 2 to 3 weeks to the start of the work, it could be go back to the fire alarm system. Most companies would say you needed 3 quotes to get a system looked at, altered, a new system installed. So therefore, the 2 to 3 weeks could be taken up by getting 3 quotes. You've got no idea how long the contractor is going to actually take.
No, sorry to interrupt you. I quite understand you have no control over this, but you are at least in a position to express a view about the importance of completing it,
correct,
which could be reflected in the time by which you think it ought to be completed. After that, it's a matter for the client. I see that.
I understand, sir, and this would have been from guidance, and again, this document would have been looked at by the enforcing authorities, not just in London but elsewhere, and no one has ever come back and challenged and said that it's too long, and I've never had any comments to say that is incorrect or wrong.
All right. Yeah. Thank you very much. Yes, Mr.
Just to be clear, following up on that a little bit, Mr. Stokes, just so that I'm clear, are you able to identify or to recall any particular guidance which told a fire risk assessor that they no longer needed to identify the cure of high-risk items that were a statutory breach, by reference to an end date, but only to a start date?
There wouldn't be a statutory breach as such, because it's a risk assessment. It's you're only looking at...
No, you're not answering the right part of my question.
Oh, sorry, sir.
I'll put it again. Are you able to identify or recall any particular guidance which told a fire risk assessor that they no longer needed to identify the cure of an item identified, such as that we're looking at here, by reference to an end date, but only to a start date?
PAS 79 would be the document I would say to go to, sir.
Right. You can't think of anything specific in PAS 79 that said...
Sir.
Right. Can you tell us what the different colours, red, orange and green, mean in this document?
Medium, high and low.
Yes. And red is statutory breach, isn't it?
You're saying statutory breach. It was a breach of a British standard or building regs, yes.
Yes. Now, if we can go to Dr. Lane's report, please. I just want to show you what she says here. BLARP 25027, page 206. That's BLARP 25027 at page 206. And if you look at paragraph 9.8.14, towards the top of your screen, she says, although Mr. Stokes is carrying out step 9 of his 11-step methodology in formulating an action plan with the aim being to reduce the fire risk from the significant findings with both physical and procedural controls, Mr. Stokes does not explain the purpose of the actions nor how they were deemed by him to impact the risk classification. And then she goes on to compare your action plans to PAS 79. And if we look at the template in PAS 79, if we can just do that next, at CTA 703, page 98, if we go to the bottom of the page, or bottom of your screen, under the words action plan, it says, it is considered that the following recommendations should be implemented in order to reduce fire risk to, or maintain it at, the following level: trivial, tolerable. Can you explain why you didn't include that in your action plans?
Because it's already at tolerable.
But in terms of the template?
It's guidance only, and there is already at tolerable.
You'd already classified the risk to Grenfell Tower as tolerable, but that was the risk rating, was that the risk rating before or after the actions that you recommended should be implemented?
Both.
Well, when you tick the tolerable box,
Yes.
Was it tolerable if, and on the assumption that the items that you identify, the action items, are completed, or is it tolerable even though they're not completed? In other words, tolerable as the building stood.
When the actions are completed, they would be tolerable.
This is why I asked the question. PAS 79 suggests that the tolerable box is ticked so as to maintain or reduce the level to what is ticked. So is the answer that it is only once, as I think you say, the actions are completed that the risk is tolerable?
In the particular case here, before they were tolerable, the actions will still make the building tolerable when it's completed as well.
Well, so does that tell us that even though there are a number of red items or red and amber items, it doesn't matter to the risk level or the risk to life level whether or not they are completed?
In this particular case, the risk level is broad enough to include tolerable within those.
How would the reader of the FRA know that?
Because on another one, it would say moderate, for instance, if the risk wasn't.
Does this mean that the risk rating in the FRA should have been higher, say moderate, and then reduced to tolerable only once all the actions had been implemented?
In this case, no.
Why in that case, no?
Because the risk within the building was tolerable, even though there was some deficiencies within the building.
Where do we see that in your FRA or in the significant findings and action plan?
On the document.
Does this tell us that in each and every case, you would have to make an assessment as to whether the tolerable box would be ticked, or another box would be ticked, as the building stood, as opposed to after the actions had been completed?
If I understand what you're saying, yes, the answer is yes.
Right. And did you do that in every single case?
For Grenfell or other buildings?
Well, let's take Grenfell to start with.
Well, in the case of Grenfell, yes, you would look at is it tolerable now? Will it be tolerable when it's finished? Yes, it's tolerable, but these are the things that are wrong within the building at present.
We may come back to that when we look at some of the later plans. But I think I'm right in saying, correct me if I'm wrong about this, that at least in the case of the Grenfell Tower FRAs, we never see you advising or assessing the risk on the basis that it is anything other than tolerable, and that cure of the outstanding action items would change that risk level. Is that right?
Correct.
So it was always tolerable regardless of whether the works were done to cure the outstanding risk items?
Correct.
Or when they were done?
Yes.
Right. Did you actually address your mind to that question that I've just asked you each and every time you did a fire risk assessment for Grenfell Tower?
All buildings.
Right. But how would you go about, just help me, what was your methodology for making the assessment of comparing the building as it stood at that risk level to the risk level that the building would have as and once each and every outstanding FRA item had been completed? What was your methodology for doing that?
How does the deficiency impact on the building? And then if it's not undertaken, what would the impact be? If it is undertaken, what would the impact be? But the definition is broad enough to take into account of the tolerable assessment.
What's the difference between tolerable and moderate?
It's just, moderate is if the outcome is moderate, it means the boxes above have been ticked differently. So therefore there's a higher risk level or harm level. And moderate would be, I'm reading in front of me here, it's essential efforts are made to reduce the risk.
Right, so do we take it that each and every red item which you've identified are not items which were essential to be undertaken to reduce the risk?
Because the definition of tolerable, from my looking at it and my assessment of it, is that it is still tolerable.
No, I don't understand that answer, with great respect. Are you saying that you ticked tolerable as opposed to moderate because at no stage did you identify any efforts to be made to reduce the risk?
I ticked tolerable because the two boxes above in the matrix indicated would be tolerable as the outcome, as in slight harm and medium. Moderate would come about if you could go back up to the box.
Yes.
On the top.
Yes, I'm looking at it.
So I can only see moderate. You'd have.
Well, no, so you're absolutely right. I do apologise. Could we scroll down, please? Thank you.
So I need to go up again. So moderate would be essential efforts made, but the piece above that in the matrix would give me the.
Right. So are we to take it that in each and every red case of your FRA items, none of those were efforts to be made to reduce the risk? They were only items where you thought there was a need for reasonably practical improvements involving minor or limited cost?
Yes.
Right. Now, let's look on to past 79 at page 61, please. Same document, page 61. I want to ask you now about the process of review of previous action plans or actions on a previous action plan, and this is covered here. Clause 20, periodic review of fire risk assessments. It says under para Roman 5 on the right-hand side, when the fire risk assessment is reviewed, consideration needs to be given to the extent to which the original plan has been implemented. Work that has not been completed needs to be identified. And if you go down to the foot of the page, please, Roman 9, it says, the original fire risk assessment, in conjunction with one or more documented reviews, constitutes a form of audit trail that demonstrates ongoing control of fire safety. Can we take it that you were aware of those principles from August 2012 when PAS 79 in this edition was published?
Yes.
If we turn the page, please, to page 62, we can see a recommendation at paragraph 20.2 in the left-hand column. And it says, when the fire risk assessment is reviewed, it should be confirmed whether work recommended in the original action plan has been carried out. And in the fire risk assessment template, if we can go to that, please, page 77 in this document, that's where the template starts. Just for everyone's benefit, there is a lengthy template here as Annex B informative, which is a model pro forma for documentation of a fire risk assessment for premises in England and Wales. If we go on in this to page 112, this recommends including a section, if you look at the foot of your screen, called Action on Previous Action Plan. And it says, have all previous recommendations been satisfactorily addressed? Tick yes, tick no. Brief details of recommendations not yet implemented. Now, again, were you aware that that was part of the PAS 79 August 2012 template?
Yes.
Thank you. If we go now to your second witness statement, please, page 12. This is CST 0186. CST 3030186, page 12, paragraph 47. You say this. At paragraph 47, on each occasion where I conducted an FRA review at the Tower, I would have made notes on a copy of the previous FRA. So is it right that when you came to conduct an FRA review of Grenfell Tower, did you look at whether the work recommended in the previous action plan had been carried out?
Yes.
You did. Now, in your fire risk assessments for Grenfell Tower from 2012 onwards, so 20th of November 2012 onwards, we don't see a section like we did on page 112 of PAS 79, Action on a Previous Action Plan. That's right, isn't it?
Correct.
Yes, why is that?
Because I undertook a completely new document.
Is it right that also nowhere in the FRAs that we have seen that you record which actions were completed and which were outstanding?
The actions, there is no definitive no. They're correct.
No. Why did you not include a section in those later FRAs to record whether the previous recommendations had or had not been satisfactorily addressed as per the template in PAS 79?
They were recorded on the new significant finding as not being undertaken.
So are you saying they were just carried across?
Carried across or added to or taken away if parts had been included.
Well, you say they were recorded on the new significant findings as not being undertaken. Did you actually monitor the recommendations that you previously made and check where they'd got to in terms of their cure, and then record that on the new FRA?
Yes, because I took the old document with me. I would find out whether the work had been undertaken, and as you showed me in the document yesterday, referenced the fire extinguishers, it was then repeated onto the new one.
But I think you accept that you don't actually record which actions have been completed and which remained outstanding, do you? So you can
not as a completely separate document, no.
No, would that not have assisted you in determining ongoing control and management of fire safety as required by PAS 79?
But I had both documents with me at the time.
But if it wasn't recorded, how could you follow from one FRA to the next whether the actions you'd previously recommended had or had not been implemented?
Because I had both documents in my hand as I walked around the building. Or I had the old one in my hand and I was writing the new one.
Yes, but you didn't have the previous one, the one previous to that, did you? You only had
previous one.
The previous one?
No.
Now, I want to turn to the Grenfell Tower FRAs specifically, and within those, I want to look at some specific topics. So what we're going to do next is to flow through all the FRAs chronologically, topic by topic. Now, I'm going to start, if I can, with disabled people. That's a title that we see in your template. And within that topic, can we start with occupancy profile, please? Can we turn, please, to PAS 79, which we've just been looking at, CTA 703, page 21. And on that page, you'll see under the heading Recommendations, paragraph 5.2, which starts, every documented fire risk assessment should explicitly set out the significant findings of the assessment, including information on the following matters. And then if you go down to E, it says approximate number of occupants. F, whether the premises will be occupied by members of the public or a significant number of persons unfamiliar with the design and layout, and if so, the approximate number of members of the public, if known. Just pausing there, would you agree that the occupancy profile is a relevant factor in the assessment of a fire risk?
Yes.
And the fire risk assessment should include those details?
Yes.
If we go to page 79 and look at the template under Appendix B, it's part of the template for fire risk assessment in PAS 79. You can see on that page, under general information, halfway down your screen, that there are two sections under that heading, 2, the occupants, and 3, occupants especially at risk from fire. And 2, the occupants, recommends that the following are included: approximate maximum number of employees at any one time, maximum number of members of the public at any one time, and associated times and hours of operation. And then section 3, occupants especially at risk from fire. And you can see the breakdown, sleeping occupants, and then under 3.2, disabled occupants. You see that?
Correct, yes.
And also 3.4, young persons.
Yes.
So children, effectively, yes?
Yes.
Yes. Now, before we turn to look at one of your fire risk assessments, would you agree, in general, that you did not include these two sections about occupants in your fire risk assessments for Grenfell Tower?
They are in the risk assessments for Grenfell Tower.
You say they are they?
Yes.
Well, we'll look at those. Let's have a look. But before we do, did you request any information from Janice Ray or anybody else at the TMO about the occupancy profile?
I would, yes.
You did?
Yes.
When did you do that first? Do you remember?
It was part of the initial document before when I first took over to ask about disabled people and what their systems were for knowing if disabled people were in the building. May I point out on this PAS 79, this is 2012.
Yeah.
This doesn't differentiate between residential buildings, hotels. This is one document for all categories of buildings.
Well, let's just study that a little bit further. Do you accept that by virtue of, and you may not know the details, but Article 5.2 and 9.7 of the FSO 2005, the responsible person, whoever that is, was required to record in the risk assessment information about any group of persons identified by the assessment as being especially at risk?
Yes.
Yes. And that would include identifying residents in a building who are especially at risk?
Yes.
Yes. And do you agree that your fire risk assessments were the way in which the TMO, or let me be neutral, the responsible person, would discharge that obligation?
Yes.
Yes. Now, can we look, please, at page 21 of this document, going back to it. This is clause 5.2i. So I didn't show you. top of the page, right-hand column, occupants especially at risk, C 3.67, in the event of fire, e.g. sleeping occupants, disabled occupants, those working in remote areas, and young persons.
So I've got, on my screen, I've just got recommendations 5.1.
You should have recommendations, and then a right-hand column with Roman, or no, Arabic I at the top.
Oh, sorry, apologies.
Occupants,
Yes.
especially at risk. You see that?
Yes.
Yes, I've read it to you. I won't read it again. I take it that you were aware that when you were doing your FRAs for Grenfell Tower, that was something that you were at least recommended explicitly to set out your findings in respect of.
Yes.
Yes. And let's look at 3.67, please, then. That's on page 14 of this document. If you look at the third paragraph down on the right-hand side, it should be towards the top of your screen, Mr. Stokes. Can you see it? 3.67, occupants especially at risk.
Thank you.
Building occupants who, as a result of their physical or mental state, age or location in the building, are at greater risk from fire than an able-bodied, fully alert adult, afforded adequate means of escape and other fire precautions, whether on a short-term or long-term basis. Again, were you aware of that guidance or principle?
Yes.
And were you aware of that definition of occupants especially at risk?
Yes.
Yes. And sticking with this document for the time being, if we can, page 36, please. This is the commentary to clause 12. Roman 8. Bottom of your screen. I think we can scroll up, please, a little to see 8 and 9. Particular account needs to be taken of occupants who could be especially at risk in the event of a fire. And then note 1 in red, attention is drawn to the relevant fire legislation which requires that, other than the case of certain very small businesses, fire risk assessments record any group of persons especially at risk. So that's in red, so particular attention. Just pausing there, were you aware of that principle when doing your FRAs for Grenfell Tower?
Yes.
Yes. Then Roman 9, particular care needs to be taken to ensure that due account is taken of disabled occupants who are often especially at risk in the event of a fire, in view of the possible need for assistance with evacuation or special warning of fire. All forms of disability need to be considered, including mobility impairment, deafness, blindness, learning difficulties, and mental illness. Again, can I take it that you were alive to or aware of that principle?
Yes.
Yes. And then over the page to page 37, Roman 14, left-hand column, final paragraph. If we go to the foot of the page, please. I think we'll need to scroll down a bit further on that page. Roman 14, left-hand column at the foot. The most important purpose of considering and recording occupants, especially at risk in the event of fire, is to ensure that adequate provisions are in place to protect such occupants from fire. Having recorded such occupants within the fire risk assessment, it needs to be clear within the documented significant findings that there are provisions to ensure the safety of these occupants. And I just draw your attention specifically to the words "to ensure that adequate provisions are in place to protect such occupants from fire." Again, I'm assuming you were aware of that principle.
Yes.
And then on page 37, on the right-hand side, please, under recommendations, you can see it there. It's just disappeared. No. Can we scroll? Page 37, right-hand column. I think we've gone back to page 21, unaccountably. Can we go to page 37, please? Under recommendations, 12.2. While it is not normally necessary to document the manner in which every factor to which 12.1 refers affects the fire risk assessment, there should normally be explicit information within the assessment regarding appropriate measures to protect occupants who are especially at risk in the event of fire. Now, again, I'm assuming that you are aware of that principle as well in the commentary and the recommendation in clause 12 of PAS 79.
Yes.
Yes. Now, in your fire risk assessments for Grenfell Tower, you did include, didn't you, I think, a specific section for disabled persons under what you've given or called section 13.
Yes.
Yes. One can put up an example of that just very quickly. CST 403157, page 21. And there it is in the middle of your screen, 13 disabled people. It is considered that the building is provided with reasonable arrangements for means of escape for disabled people. And although it's expressed as a statement, there's a question mark. And answer ticked, yes. This is the 2014 FRA. Now, I'll just show that to you. We'll come back to the text of this shortly. Can we look at what you say in your second witness statement about this?
Mr. Millett, I'm sorry to interrupt you, but we've been running for an hour, and I just want to check that Mr. Stokes doesn't feel the need for a break at this.
I'm okay, thank you very much, sir.
We shall run through to 1 o'clock if we don't have one. That's just so that you're aware.
Thank you very much, sir, yes.
Right, and I think it's also important that I ask the transcriber whether she's happy to keep going for an hour.
I'm fine, thank you, yes.
All right, thank you very much. Yes, Mr. Millett.
Right. CST 3030186. That's the first page of your statement. I would like to go to page 38, please, and paragraph 143. Page 38, 143. And you say there, and this is under the heading G, disabled people, and you say under paragraph 143, I was at all times reliant on the KCTMO to provide me with information concerning any residents who may have sensory, physical, or any other impairment. Indeed, I understood from Ms. Ray that the KCTMO had a, quotes, comprehensive programme to gather information about tenants, including disabilities, and their physical ability and mobility to respond to any emergency situations. And you've had a footnote 4 in there, which at the bottom of your screen says this reference is to be found by, for example, page 23 of the June 2016 FRA at section 13. Do you mean in your statement here that you were reliant on Janice Ray to give you this information?
Yes.
And if you look down the page at paragraph 144, you say this, I received no such information in relation to residents at the tower, hence the comments made in my FRAs referred to in question 54. I did not proactively seek information about residents, but would have drawn attention to such an issue as part of the FRA if this was known about.
Correct.
Does that mean that before you carried out a fire risk assessment for Grenfell Tower, you didn't ask Janice Ray for up-to-date information on the residents and occupancy profile, especially at risk?
It was my understanding that I would be told from them, from previous meetings, because it was arranged that I think a lot, when I first started, we went through this in depth and provided a set of PEEPS documents to the TMO. And I would be told, the emphasis was on the TMO to tell me, as the risk assessor, of anyone that needed special needs.
So just picking up on the last part of your answer there, is the answer to my question that before you carried out a fire risk assessment for Grenfell Tower, you did not ask Janice Ray for up-to-date information on the residents and any occupants, especially at risk?
Correct.
Why did you not proactively seek that information from Janice Ray, given the importance ascribed to recording information about occupants, especially at risk, in the Fire Safety Order 2005, and particularly past 79, as we've seen?
Because it was an ongoing situation with the TMO and Janice that she would inform me, no matter where they were, within any building, at any time. So I could be... The FRA might be undertaken August 2014, but if they had a resident that was moving in 2 weeks after I'd undertaken the risk FRA, she would inform me that it would alter the FRA for that building.
Well, I can see why you say it would. My question is why you didn't think to ask her every time you were about to do an FRA for Grenfell Tower, Janice, can I please have your up-to-date occupancy profiles so that I can check and see whether there are any occupants especially at risk?
It was the reverse. She would tell me when she knew that there was anyone in there at risk.
Why did you leave it to her to do that rather than you actively prodding her?
it was a given that was the sort of information I would be given as they knew of residents in the building.
To the best of your understanding, was that her understanding as well, that the onus was on her to volunteer the information to you and not on you to seek it from her?
Correct, because that has happened on numerous occasions in the past, and I have undertook peeps for people within buildings.
On the subject of peeps, let's go then to...
Sorry, before we leave that, you say in your statement, the one we've got on the screen, that you received no information about the residents in the tower. Is that right?
Correct.
I mean, did it occur to you that there might be some children living in the tower?
Agreed, yes. But
That you didn't think to ask her, were there any children in the tower, and if so, in which flats?
But it was a given that there would be children in the tower. The fire safety order is young people, is a workplace. So it is whether not... The fire safety order is about workplaces and work. So the young children section is about young children undertaking work, employment, and that is because of their immaturity, inability. It is not to do whether they sleep there. It's the same as a hotel. In a hotel, you would expect to find families staying in a hotel, but you do not make a difference between a family staying in a room, whether they've got one child, 4 children.
So I think what you're saying is that you didn't need, in your view, you didn't need to make any, or at least to consider, how children might be affected if there was a need to get out of the tower.
You would assume there would be a supervised by their parents or adults.
Yeah.
You would know there'd be children in the building. It's a sleeping
that's
building.
what I thought. Yeah. All right. Thank you very much. Yes.
Sorry, can I just say?
Yes, I'm sorry. Please do. Yeah.
That the domestic dwelling is outside the control of the FRA, so you would know there would be people in of the fire safety order. So you would know there'd be people in the flats. But it's the makeup of the people in the flats. You would assume the only disabled part of it. Again, you wouldn't know that unless you're told that information.
Right.
Well, you wouldn't know it unless you were told the information. Was it your assumption, having received no information in relation to the residents in the tower, that there was nobody in the tower of any relevance to Section 13 of your FRAs at any time?
For the FRAs, correct. One point, after the last FRA was undertaken, I was asked to go to the tower, and I'm trying to think, it's November 16, to undertake a visit as requested by the TMO, which was outside the remit of the FRA. And I saw a mobility scooter, and I raised that as a question.
Yes, you're right, and we will come to that in due course. But a moment ago, before the chairman's questions, you told us that it was a given that it was the sort of information that you would be given as they knew, that's the TMO knew of the residents in the building. You say it was a given. Did you and Miss Ray ever actually agree that the onus would be on her to provide information about residents, especially at risk from fire?
I think it would be, yes.
So you say there was a specific agreement, do you?
Well, if she was told, yes.
When did you reach that agreement with Miss Ray?
I think it was right at the beginning, wasn't it? In the letter. Sorry, I can't remember the actual date. September 10, when we went through all the items about the criteria of what I would put down. We covered yesterday, sir.
Yes, that's the letter of the 27th of September 2010. If we go to that, it's at CST 403061, please. And in it, if you go to page 3, now, that's CST 403061. what is on the screen, Mr. Chairman,
Well, you've probably got what I've got.
is
which
not, indicates a problem, potentially.
Yes.
I do hope not.
I would hope this isn't going to take too long to sort out, but it's hard to tell, isn't it?
Yes.
Well, it sounds like it's going to take more than the minute or so that I'd originally hoped. So I
Yes.
think, sorry, we're going to have another short break, Mr. Stokes. So I'm going to ask you to go with the usher. And same terms as before, no talking to anyone about your evidence, please. And we'll get you back as soon as we can. Right, Mr. Minnick, we'll leave the room and
Yes.
you can ask the usher to come and get
Yes, Mr. Chairman, certainly. Thank
ready.
you.
Yep. Could you ask Mr. Stokes to come in, please? Welcome back, everyone. We've come back into the room to explain that, unfortunately, we're still having significant problems with document display. I can't explain the particular technological problems we have, but suffice it to say that at the moment, we still can't display any documents in the room. So the best course, in my view, is that we call a halt at this point for lunch. And we'll resume, if we can, at a little earlier than usual at 1:45. That will give an opportunity to look into the problem a little more carefully, and we hope to solve it so that we don't have any further difficulties this afternoon. So we're going to rise now. We'll resume at 1:45. Mr. Stokes, I asked you to come in just to ensure that you were in the picture and understood what's going on. I'm sorry we're causing these sort of difficulties. But there it is. We'll resume at 1:45. Please don't talk to anyone about your evidence while you're out of the room over lunch.
So,
And we'll see you then.
thank you, sir.
If you'd like to give the usher now, that'll be great. Well, there it is, Mr. Millett. I'm sorry. I think that's the best thing we
Yes.
can do, and it gives people a chance to sort out the problem.
Very good, Mr. Chairman. Thank you.
So we'll
Yes.
say 1:45 then, please. Okay.